Good evening, everyone, and welcome to The Truth About House Bill 3653, Illinois Justice Reform Legislation. I am Linda Flowers, president of the Carbondale Branch NAACP. The format for this evening is very simple. We will begin with our special guest, followed by a question and answer period, and then closing remarks by our Branch Criminal Justice Committee Chair, Nancy Maxwell. If you have questions this evening, please use the Q&A function at the bottom right of your screen. Our speaker for this evening is Senator L.G. Sims Jr. Senator Sims has served in the Illinois legislature since 2012, first in the House and in the Senate since January of 2018. Senator Sims sponsored House Bill 3653, authored by the Illinois Legislative Black Caucus. So now, without any further ado, I present Senator Sims.
Well, thank you, Madam President. It is a privilege and an honor to be with all of the branch members of the NAACP. As a life member of the NAACP, I'm keenly aware of the difference that the NAACP makes in communities, not just around the state of Illinois, but around the world. So I want to commend all of the members of the NAACP for joining this evening, and all the members of the public to come and find out the truth about the Safety Act, which is House Bill 3653. So let me start. House Bill 3653, the Safety Act, is the most comprehensive pro-safety, pro-reform, pro-community piece of legislation that's been passed in the state, not just in the state of Illinois, but around the country. It modernizes sentencing laws. It ends the use of cash bail, but it still allows for an individual to be held if they are a threat to safety, or they are a threat to not appear to answer the charges before them. It also institutes a certification and decertification system statewide for law enforcement officers, requires the use of body cameras statewide by 2025, reforms the way crowd control response is done by law enforcement. Also invest in law enforcement training standards. It prevents the destruction of law enforcement misconduct records. It connects substance abuse treatment programs with first responder duties, creates two police misconduct databases for public viewing and transparency, requires police to develop a plan to protect children and other vulnerable populations when executing search warrants. It empowers the Attorney General to investigate deaths occurring in police custody. But it also invests in and addresses officer wellness and training. It invests in mental health awareness and screenings for all law enforcement officers, invest in training protocols, but also bans the use of chokeholds and other extreme measures, but also establishes a statewide use of force standard by the year 2022. Again, this is a pro-safety, pro-reform, pro-community piece of legislation and now law that focuses on safety for our communities, accountability for law enforcement officers, and fairness and equity in our criminal justice system. And that on all of those things happening today. What the bill does not do, it does not defund the police. It does not remove qualified immunity for law enforcement officers. It does not change or take away collective bargaining rights. Does not allow those who are charged with a serious offense or risk to another person or risk to be willful flight to be released. That does not allow that to happen. It doesn't prevent a judge from revoking pretrial release. It also does not alter prison time for individuals serving time for heinous crimes. So there are a number of misconceptions, misinformation, and disinformation campaigns going on. But the reality is the Safety Act is all about investing in safety across our communities and making our communities more safe. So with that, Madam President, I'm open to answering any questions, and I'm looking forward to the conversation this evening.
Okay, Senator, right now there are no questions in the Q&A. People are still joining in. So if you want to talk a little bit more until we can get a couple.
That's okay. I would certainly love to talk about the Safety Act, but also the process leading up to the Safety Act. You know, let me talk a little bit about particularly the end of cash bail, because the end of cash bail is a significant policy change here in the state of Illinois. But what the end of cash bail does not mean, it does not mean that individuals will not be held accountable for their actions as a result of the Safety Act. The Safety Act specifically requires that the size of someone's bank account not be used to make a decision about whether or not they should be held on a pretrial basis when decisions are being made. What the Safety Act calls for is for a judge to look at an individual's threat to community safety or to a person, or whether or not they're not going to show up, and then making a decision about whether or not to hold that person in custody or let them go. What you find is an individual who could be a threat to public safety may have access to money, but then be allowed to go free, when someone who does not have access to money would not be allowed to go free and be held in custody. There's a situation that I've often referenced in terms of the use of money bond and the ability to make decisions about pretrial release or detention, because money has never been shown to make us more safe. It is merely a tool used to incarcerate those who cannot afford nor have the resources to get themselves out of pretrial detention. But so there's a circumstance and situation a couple years ago. So the end of cash bail really started several years ago when we passed the Bail Reform Act of 2017. So in 2017, we were trying to make a system that focused on individuals who were threats to public safety versus those who were who should be incapacitated because they were a threat to public safety versus those who were not. And what we found, and during this examination, there were a number of instances and examples that we found. One that stood out to me, stood out to me even to this day. There was a young woman that she was homeless and mentally ill, and when she went into a convenience store and stole several pieces of fruit and several pieces of candy. When the police officer showed up, because she was caught, the store owner called the police. When the police officer showed up, the police officer asked, the store owner said, "I want her arrested." The law enforcement officer said, "Okay." He offered to pay the store owner for the piece of the items that were stolen. So as I mentioned, the young woman was homeless, mentally ill, and pregnant. So the store owner said at the time, I don't want you to pay for it. I want to teach her a lesson. I want her arrested." So when the police officer, then following the direction of the victim, took the person into custody, took them to the county jail, where the homeless, mentally ill, pregnant woman then spent more than 160 days in jail. And I mentioned she was pregnant. During the time she was incapacitated in county jail on a pretrial basis, she had the baby. The baby was then taken into DCFS custody. So as opposed to, while she was in custody, she received some services, but the response that we are trying to examine as we reimagine what public safety looks like is, as opposed to sending that mentally ill, homeless individual into county jail where she spent over 160 days at $142 per day, as opposed to sending her, having that response, why not invest in the treatment options that would divert that person from the criminal justice system in the first place? That's how we reimagine public safety. We have been on this path towards this mass incarceration path for the last 40 years. And we need to change the way that we focus and change the things that we think about and the way that we look at criminal justice in the state and around this country. So I think we're starting to see some questions start to roll in. So I'm gonna stop there. But suffice it to say that the end of cash bail is not. It is about focusing on a person's threat to the community or to public safety, or a threat to them not appear to answer charges, not about the size of their bank account. So with that, Madam President, I think we've got some questions.
Yes, Senator. First question. What type of mental health services does the bill provide for the police?
It invests in mental health training and services for law enforcement officers, so that we know that law enforcement officers see some tremendously difficult things. So we want to make sure that they are whole as they go about and do the work that they are charged with doing. So we've invested in supports for law enforcement officers. I have previously sponsored legislation that allows law enforcement officers, if they seek mental health services, to not be deprived and removed from law enforcement or from active duty. The purpose to me is we want law enforcement officers to get the help that they need. There was an incident recently in the city of Chicago where a law enforcement officer committed suicide after I guess all the facts have not been out, but I know he had inquired about retiring, told he was too young to retire, and then committed suicide. That is tremendously difficult. So we want our officers to be whole. That's why the opposition that you're hearing about the Safety Act, it goes against everything that we are trying to do. You can support good officers and still want reform in the profession of policing, because it is a profession. So the Safety Act invests in those supports for law enforcement officers and the trauma that they experience, and there is also additional support that would happen in terms of the training that is given through the Illinois Law Enforcement Trainings and Standards Board.
So are there any provisions being made for courthouses, Senator, to find revenue substitutes after cash bail is eliminated?
Well, that's certainly something that we've had conversations about, and we're open to having those conversations with members of with counties around the state. What I would ask for anyone who's listening to this discussion tonight, reach out to your local county clerk, reach out to your local sheriff, and ask them to come and have engage with us on these discussions and in these discussions, so we can have legitimate open dialogue about the challenges that they face, because I want to have them just as they do.
So why do you think, Senator, there is so much misinformation being spewed by mostly rural law enforcement?
Honestly, I believe it's politically motivated. This is we have moved past the desires and the issues about public safety, and we're over into politics. To me, public safety is not a partisan issue. Public safety is about ensuring that communities have all they need to enjoy the quality of life, so that all communities enjoy the same quality of life. But that's not what you're hearing. You are hearing a narrative be created to try to talk about the politics associated with the Safety Act and with other policies associated with improving the profession of policing. That's why you hear phrases thrown around like defund the police. The Safety Act in no way defunds the police. In fact, there are more resources built into the Safety Act built into Illinois state government as a result of the Safety Act. In the budget that was recently proposed by Governor Pritzker, which we are negotiating right now, there was more than $20 million included in the bill, in that budget proposal, which I would imagine you'll see some additional resources invested. Those resources include resources for additional training, additional resources for body-worn cameras, additional resources for investments in trauma services. So we have moved past the policy of improving our public safety and into the politics. So you're hearing politically motivated responses to the Safety Act. And I would note that of the individuals that you are hearing, they were invited to the table. The sheriffs, the chiefs, the state's attorneys, they were all invited to the table over 4 months and 4 days from the first hearing of the joint hearing of the Senate's Criminal Law, Public Safety, and House Judiciary Criminal Committee. There were 126 days where individuals were invited to the table to participate. They participated in 9 public hearings, 30 hours of testimony. So it's not about the policy, it's about the politics. And that's what this has devolved into. And it's unfortunate because you cannot play politics with public safety.
So here's a follow-up to that question. How can we best counter this deliberately fear-mongering campaign?
Madam President, I'm so glad you asked that question. Number one, be informed. Be informed about what the Safety Act is, and more importantly, what it is not. And by doing that, by coming to conversations like this, but also we have resources available for you. HB3653.org, HB3653.org is a website that we have created for you. It's a resource that you can go. You can find information about the Safety Act. You can find information from, because Madam President, there's also a narrative out there that this is bad for victims. Crime victims are going to be harmed by the Safety Act. You will see that crime victims assistance or crime victims are in favor. Crime survivors, not victims, crime survivors are in favor of the Safety Act. You find survivors of sexual assault are supporters of the Safety Act. Survivors of domestic violence are supporters of the Safety Act. So all of those supports have been outlined at House Bill 3653 or HB3653.org. So you can inform yourself. That's number one. Number two, reach out and talk to your neighbors about what the Safety Act is and what it isn't. So we can make sure that others know that the Safety Act is rooted in improving the quality of life for everyone. James Baldwin, the famous author, once said that not everything that we face can be changed, but nothing can be changed until it's faced. We have to face the differences in policing that exist, and until we do, we can't improve them. So you can again, as I said earlier, you can support good officers and want reform in policing, and that's what the Safety Act is all about. But it goes even farther than that. It goes into speaking towards how we improve safety in our communities. So tell your neighbors that. Don't let the fear when oftentimes when we hear those who want to support and spout fear, when the loudest voices often win. And that, as my grandmother used to say, if two fools are yelling at each other in the street, nobody knows who's the sane one. Well, we know that oftentimes when we know that we're right, we won't yell back at the ones who are wrong. However, we need to make sure that we are countering the mis and disinformation campaigns with facts. We are countering the mis and disinformation campaign with the truth, and that's how we will beat back the mis and disinformation campaign. We recognize that criminal justice system in the state of Illinois, and with crime in itself, people are not deterred from crime by more harsh penalties. They are deterred from crime by the fact that it's certain that they're going to be caught, and by the fact that when they are caught, the punishment is swift and severe. Well, right under a 2019 statement, a study done by crime statistics collected by the Illinois State Police, statewide, that is statewide, 8 out of 10 crimes go without an arrest. That is statewide. So we have got, if those statistics don't yell out and scream for us to reimagine public safety, I don't know what do.
Next question. I
Mhm.
heard there are occasions of a term in the bill that is used in different places with conflicting definitions. Are there plans to clarify those aspects of the bill that are ambiguous or inconsistent?
Well, I would certainly welcome anyone who has questions or concerns about ambiguous language, or language that they don't believe is clear, to bring those to our attention. What's we have I've said from the very beginning what we have always talked about. I will go anywhere, any place, and any time to talk to anyone about this piece of legislation or any other. That is one thing that folks will know about me who have worked with me, that I am certainly open to hearing others' ideas. I know that I'm not the smartest person in the room, but I know I'll make sure I work the hardest. So I will certainly, if there are questions or concerns or issues, I'm certainly open to hearing them. But I can't hear them if nobody brings them to me. So if the questioner has specific issues, yes, I certainly will be open and willing to hear them and talk about
Okay, and maybe they could put those in the chat.
them.
Next question. With the bill maintaining qualified immunity, how do lawmakers expect accountability after the use of banned force?
Well, we are the bill. The Safety Act also does include a task force to examine qualified immunity. So as we move towards the end of the spring session, I would imagine that there will be some discussion about what qualified immunity is and what qualified immunity is not. What the bill does call for, though, if there is the use of force that is not appropriate, the bill does call for a decertification process. Whereas previously, the only way a law enforcement officer could be decertified was upon the conviction of a crime. That's not the case any longer. An officer can be decertified based on actions that are inappropriate, and being charged with certain crimes. So that if the person is not, if the officer for using force is not personally liable, they could still be decertified. And if their actions are found to be a violation or outside of policy, they could still be held liable. But the decertification process is currently in the bill, and those discussions about qualified immunity continue.
Next question. With prison gerrymandering ending, what does that mean for this region?
Well, I think that we are having those discussions right now. So I honestly don't know what that means for the region, because I don't know what the final statistics look like for our final census data. So I can't answer that question today. But I would imagine that as we move forward towards the drafting of drafting of a map, the passage of a map for the next 10 years. We will come, as we get those final statistics, census statistics, we'll know more. But I don't know that right now.
Okay. How will risks now be evaluated during pretrial? How will risks be mitigated and managed during pretrial?
Great question. So the last several years I have been engaged in as part of a process as outlined by the Illinois Supreme Court, which engaged judges, stakeholders, legislators, interest groups, to reform the state's pretrial system. And those discussions those discussions led to the production of a report that was then presented to the Illinois Supreme Court. And we continue those discussions through our implementation task force. What we found as part of that initial commission work was the passage and the settling on a verified risk assessment tool. There was a pilot program that started several years back to engage and find a verified risk assessment tool. And what judges will then be able to do is refer to that risk assessment tool as they make these pretrial decisions. But then also it gives the judge the ability to look at the totality of a person's record and as they make those pretrial decisions. So that as that verified risk assessment tool is made available to judges, they will make decisions based on that and based on the person's previous record. This is much more advisable to just having a system based on an in or out system based on access to money, because if an individual has access to money, or I'm sorry, in the world after the passage of the Safety Act, which coincidentally, the end of cash bail does not go into effect until 2023, intentionally to give the additional runway so that we work through and understand what the challenges are. But so as we work towards that verified risk assessment tool, it will then, it gives the judges the ability to make decisions based and then set conditions of release based on a person's threat to the community or whether or not they have a challenge. Now, going back to the young lady I mentioned earlier, as opposed to holding that young lady in custody, a judge could set conditions where, separate and apart from the money bail, which clearly a homeless person, even if the bail was $10, the young lady she could not have come up with it because she was homeless. But the judge could, under those circumstances, set pretrial release conditions requiring that the young lady go into mental health treatment, that she go into, she get housing, housing assistance, all those other things. So the judge would have the ability to make decisions separate and apart from a person's access to money, that could set conditions that would allow for the person to improve their life and not be a threat to the public.
Next question.
Mm-hmm.
With police departments having to permanently keep misconduct records, how will a citizen know if a complaint was filed? Are they uploaded in a state database?
That's another great question. Thank you. That's the purpose for those two databases that I mentioned. Here's another good example of the ability to eliminate and move away from the mis and disinformation campaigns. There are some who will tell you that every complaint made against an officer is going to go into this database. That is completely false. The only things that are going to go in this database are instances where a law enforcement officer is found to have engaged in the behavior that is alleged. So if an officer has a pattern of founded misconduct, maybe if it's excessive force, maybe it's maybe it's badgering the public, whatever that might be, and those are founded, those will go into the misconduct database. If there are complaints made that turn out to truly be frivolous, they will not make it into the public database. But that will go into that database that an individual could then so that would be available to the public, so they will know that if an officer is decertified, why they're decertified.
Okay. What changes will there be made in screening potential police applicants? Will military experience still be encouraged?
I have said all along that since I started this work, and Madam President, you mentioned that I've been in the office since 2012. I started in the House and then served as chairman of the House Judiciary Criminal Committee for several years before moving to the Senate and serving as chairman of the House or the Senate's Criminal Law Committee. What I have been focused on is this. I've been focused heavily on this reform journey in criminal justice. But it's just that it is a journey. Reform is not a destination. It is a journey. We are continuing to invest and focus on what changes need to be made in the profession of policing. That's why in the Safety Act, you hear me talk often about the move from the warrior style mentality to a guardian's mentality. And that comes from, while we recognize that military service has its place, and it's an area that we want to encourage our veterans to come in and engage in the profession. But there are also other professions, and that we are looking at trying to target, and making sure that we have more individuals who maybe have a psychology background, or who have a social work background, and other individuals who are coming in and will engage in the profession of policing to make it a more diverse, a more broad-based profession. Our military service people do a tremendous service, and we owe them all a debt of gratitude. But they're not the only profession to where we would have that we should have a preference. So we are continuing to have discussions about what the professional policing will look like, and eventually how it will interact with law enforcement, how it will interact with communities. That's how you reimagine public safety. You cannot continue to do what you did yesterday and expect it'll be different. It'll have a different outcome tomorrow. Doing the same thing and expecting a different result is the very definition of insanity. So we will reimagine what our professions look like, and what as we have that guardian's mentality, and how law enforcement officers who are problem solvers, who work with communities every day to engage. I mentioned that I come back to that example of the law enforcement officer who offered the situation I talked about earlier, who offered to help solve the problem, but ultimately he did what law enforcement officers had to do, which is answer the call based on when a crime has been committed. But law enforcement officers want to be problem solvers, and we want to give them the tools. That's why you see the significant investments in public safety. You see the significant investments in training, and we're going to work to change that mentality from that warrior style mentality. That's why you see the move away from the purchases of military grade equipment. We want to have individual law enforcement officers work in concert with communities, working hand in hand, to be partners with communities. And that's what the Safety Act is all about.
Okay, here are two related questions.
Mm-hmm.
Can you please restate the status of the bill, and what is the timeline for when the main parts of the bill will go into effect?
Well, the status of the bill is that it's now law. Safety Act was signed into law by the governor last week. So it is law. There are different touch points and different effective dates for different elements of the bill. For instance, the end of cash bail does not go into effect until 2023. The requirement that body-worn cameras be worn by law enforcement officers are implemented at different times. So if you're a municipality, a county or municipality of 1 million or more, then your requirement goes into effect in 2022. If you're a municipality of 50,000 people or less, the requirement doesn't go into place until 2025. For the statewide use of force standards, they won't go into effect until 2022. So it just depends on the portion of the bill that we're talking about.
Next question. Are sentencing laws going to be retroactive?
Well, they're prospective, not retroactive. So we continue to work through the sentencing and modernization of our sentencing laws. That's an area where, as I mentioned, this comes back to that journey statement again. This is not that there are going to be other reform measures taken up during the spring 2021 session, and there will be other reform measures taken up. So we are, just because the Safety Act is the most pro-reform, pro-comprehensive, or most comprehensive pro-community bill that's ever been passed, doesn't mean we're done. We will continue the reform journey. So there are other ideas. And you asked me another question earlier, Madam President, about how individuals can get involved and how they can combat the misinformation and disinformation campaign. What I would take that a step farther and would be an assistance in this area. If you have specific suggestions, I would certainly welcome and encourage listeners and participants this evening to reach out to myself, reach out to Representative Justin Slaughter, reach out to Senator Robert Peters, who is our other partner in progress, to bring up those ideas. My email is esims@senatorlgsims.com. That's esims@senatorlgsims.com, or you can visit my website at senatorlgsims.com. You can also follow me on social media. So there are a number of ways that you can reach out to us, and I would encourage everyone to do that. If you have if you have ideas, please bring them to us. That's what makes the Safety Act so much different than other reform actions or reform efforts in the past, because activists, people who wanted to lift their voices up, they were at the table. They were at the table. They were not just happy to be sitting at the table. They were at the table helping to set the agenda and set the menu at the table. So please, 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 if you have ideas, bring them to us, because that's the only way we're going to have the reform that communities need, if we all have and are speaking the same language. So if you have ideas, please share them with us.
Okay, there are still questions about bail. How does the current bail system work? And can you please explain how the monetary bail provision works?
So again, let me start with the last one first. So the monetary provision, the way it works is decisions will not be made based on a person's access to cash, access to money. So another example, Kyle Riddenhaus. Most of us have heard the name Kyle Rittenhouse now. Kyle Rittenhouse was a young man who was accused of killing individuals during riots in Kenosha, Wisconsin. His bail was set at $2 million to presumably keep to protect the public and make sure that he would be held in custody. Well, what happened? Kyle Rittenhouse had access to money. He had some of his wealthy, famous benefactors come in, pay the bail off, and after the bail was paid off, what happened? He disappeared. So he couldn't. The courts went to find him, couldn't find him. Had to send folks out to find him. He still couldn't find him. They had to wait until he was able to. He wanted to come forward and tell the court where he was, give information about his background and where he was staying, etc. No different than let's take Kyle Rittenhouse out of the situation. There are circumstances where individuals who are engaged in drug or gang activity, who are violent people, but they have access to cash. They are engaged in gang or drug activity, and they go before the judge. The judge says, "Okay, I'm going to set a bail for $1 million. $1 million for once the bail amount is set, you then pay 10% of that amount." Judge says, "Okay, I'm going to give you a bail for $1 million. Pay $100,000. If you are part of a drug enterprise, the $100,000 would show up, and you would go free." So that is how the cash bail system works. Under the Safety Act, that calculus is no longer going to be done. What the judge would do is consider the crime that the individual is charged with, as opposed to setting an enormously high bail. They would look at the person's threat to public safety, threat to an individual person, or if they are a flight risk, and at that moment make the determination of whether or not the person should be held in pretrial detention. An individual who is engaged in gang or drug activity, who is shown to be a threat to the community or a threat to individuals, that person would likely be held in custody. That would not happen under the cash bail system. And coincidentally, or additionally, when that person were released, then there will be conditions on that release. Whether that person has to engage in job training or or crisis or anger management. What a whole host of conditions could be set. Let me take the individual, the threat to public safety off, because if the person is a threat to public safety, he's not getting out. So if the person is if he's shown to be a threat to public safety, or engaged in criminal act, or engaged in activity that is threatening to public safety, he's not going to get out. Those individuals will be held in custody. I'm speaking more on a non-violent offender. Conditions could be set for that individual if they're a non-violent offender. If they're a violent offender, they're going to be held in custody. A non-violent offender would not be held, and conditions could be set so that individual could get the job training, could get access to anger management, etc. But a violent offender, that violent offender is going to be held in custody as opposed to that non-violent offender.
Next question. Do you foresee any challenges to having the provisions of this bill being followed by communities across Illinois? Also, is there any money allocated for helping communities adjust to and enforce these provisions?
Well, I would say I don't know. I don't think there are going to be challenges to communities being able to implement the provisions of the law. Because it allows us to as we focus on the changes that are happening in our criminal justice system, as we focus on the changes that are happening in our communities, then we will see that the changes they're going to bear beneficial fruit. But is it going to happen overnight? No, I don't want anyone to believe that these changes will bear fruit overnight. We have the Illinois Department of Corrections. The population in the Illinois Department of Corrections is, I think it was 29,000 recently. Several years ago, it was at 38,000. So we continue to trend downward. But as those resources trend in other directions, we can invest in the services necessary to have better a better public safety system, a better criminal justice system, more investments in prevention. That's the goal. You want to keep people from the criminal justice system in the first place. We have relied on the mass incarceration and under-resourcing of communities for far too long. That's why the Safety Act calls for those increased investments in areas, increased investments in education, increased investments in healthcare, increased investments in economic opportunities. Because then that's the other reality, that the Safety Act doesn't sit in a vacuum. The Safety Act is part of a broader strategy to address systemic racism. Now, because if you have a failure to invest in young people in the education system, they end up in the school to prison pipeline, which is a criminal justice system. And if you don't have individuals who are economically secure, they end up in the criminal. They engage in behaviors that are going to be detrimental, and they oftentimes end up in the criminal justice system. If you have individuals who have mental health disorders or substance abuse challenges, they oftentimes end up in the criminal justice system. Nearly half of most jail populations or county jail populations are inhabited by individuals with mental health challenges. So we have to invest in those activities at the county level, at the state level, so that we have the ability to redirect our resources and redirect our activities into keeping people from the criminal justice system in the first place.
Back to prison gerrymandering.
Mm-hmm.
This directly addresses how inmates are counted. They then have to list their home addresses where their families reside. Who would have access to this list? Those counties that lose population, what happens in that instance?
Well, again, I think we have to wait and see what the statistics look like. But as an individual lists their home address from where they were located, that's where they'll be counted. So they'll be counted based on that information. As the counties then redistrict and reapportion as well, they would also certainly have access to that information, because that's the Secretary of State has as the repository of those well, that count and that information. So as just as the state does reapportionment and redistricting, so will counties have to do. Counties and municipalities have to do the same. So that information would be forthcoming after we have final statistics.
You mentioned that only conduct found to be improper will be tracked for officers. Does the bill make changes to the grand jury system for choosing to prosecute officers, or make any other adjustments to the process for finding officer conduct to be improper?
It does not change the grand jury process. But again, the certification and decertification process is what is outlined here. I'm curious to and I would hope that the questioner would reach out to me. I'm curious about some of the ideas that they have for those changes, because those sound like an interesting concept. So if they could reach out to me directly, I would love to have some additional conversations about that.
Okay. When you previously stated that the Supreme Court commissioned a study in police reform, are you referring to the Illinois Supreme Court or the United States Supreme Court?
The Illinois Supreme Court.
Seems like police leaders have complaints about the bill, but have there been any surveys of police on the street, like that officer who would have paid for the homeless woman's food rather than arrest her? Would he have had more leeway?
Had more leeway to do?
I assume not and wouldn't have to have arrested her.
Well, I would think that law enforcement officers have a tremendous amount of discretion in terms of making some of those decisions. But also, I would imagine in that circumstance that the individual being as adamant as he was, that officer would certainly want to make sure that he was complying with the wishes of the victim in that crime. So that would certainly be my guess. I can't speak for what the officer was thinking in that moment, but that would be my guess. When I talk about reimagining public safety, that's also when I come back to being problem solvers. Maybe the officer could have taken the young lady and put her in the car and then talked to the store owner and had more conversation and talk the person down. I don't know, but that's when the ability to be problem solvers and when you have the ability to be those problem solvers, and we have the ability to talk to people, dealing with them in very difficult moments, that's when you have this change in the profession, when you have circumstances where individuals can have these very tough conversations, see people in very difficult and tough circumstances, but are able to solve the problem. And that's really what communities are calling for. Because let's be frank. If the circumstance happened in a community where the population were not Black or brown, this circumstance would have been, the reaction might have been a lot different from the store owner and or the person who were engaged in the activity. So we've got to make sure that all communities have the same access to equity and fairness and equity and justice. So that's really what these discussions are all about, making sure everyone has the same access to the same system of justice and are treated the same.
How will police departments be held accountable for the measures where they will be required to report out, offer additional training, use body cameras, etc.?
Well, again, that's law enforcement officers law enforcement departments, that is, they are charged with following the law. And I would certainly imagine that as individuals go forward with following the outline of the law as outlined in the Safety Act, they will comply accordingly. There will be the Illinois Law Enforcement Training and Standards Board will continue to, they will track the officers who are completing the training and holding officers and departments accountable. To that, the Law Enforcement Training and Standards Board is the board that is charged with monitoring training for officers. And you will see those discussions continue to happen. You will continue to see that board have a much bigger role in those activities where departments and individual officers are engaging in the training necessary and required by the Act. So as we move forward, you're going to see much the reporting done to the board, but also to the state, because that's how, because the law being passed is one part of this puzzle. The other part of this puzzle is the implementation. So we have to have the law has to be implemented properly, and that's where the monitoring, that's where the tracking of the hours, et cetera, hours of training, et cetera, is going to come into play. So all of those things will happen as we move forward with implementation, and the governor, his administration, they are committed to working with us to making sure that that this law is implemented properly.
So how would you respond to a department that says, we don't have money for body cams, or we don't have money to hire someone to input or process the body camera data?
That they would be in violation of the law.
Okay. Do you know if there are any mental health measures in place right now for officers? And they want to know if the Safety Act addresses burnout or compassion fatigue.
Well, again, there is additional investments in mental health services for law enforcement officers. There's investments in addressing the trauma that law enforcement officers experience. That's why we want to make sure that we built those supports into the Safety Act. There was, again, as I mentioned previously, this is an area that I'm particularly sensitive to, because officers who don't feel that they are being supported, and when they do see tremendously difficult things, that manifests itself in negative ways sometimes. Going back to the experience that we talked about with the officer who just recently committed suicide, we don't want our law enforcement officers to experience, to feel like there is no hope. So the Safety Act invests in those additional resources, but there's also supports that have already happened. Again, I mentioned the law the bill that I sponsored that will allow an officer to seek mental health support without losing their ability to be a law enforcement officer. That's how we're going to get through this together, by having those investments and walking this road together. So that's why you have that investment from the Safety Act in those mental health services, in those trauma-based services, to allow law enforcement officers to seek the help that they need to be whole.
And then someone wants to know if you can explain how to file an anonymous complaint. I'm not sure if this is a complaint against an officer, department, or against the bill.
Yeah, no, I would imagine it's an anonymous complaint against a law enforcement officer.
Okay.
So what as the Safety Act calls for and allows for is an officer, or is an individual to file a complaint against an officer without having to sign a sworn affidavit. But prior to the passage of the Safety Act, the only way an individual could file a complaint against an officer was if they signed a sworn statement under penalty of law that they were, that under penalty of perjury, that that their statement was correct. They might have gotten a detail wrong or something. And there have been cases and instances where individuals were then threatened with perjury by having details wrong in their statement against, like a statement that they filed. So, and what we found in having discussions with individuals were that they were then challenged, and there was this chilling effect on individuals filing these filing complaints against law enforcement officers. So they didn't file complaints because they felt that it felt that there was going to be retribution or reprisal. So now, under the Safety Act, an individual could go to go do a department, and they would say they want to file a complaint. Then, as they file the complaint, they would then file that complaint with the supervisor on duty or a superior officer, and when they could do that in an anonymous way. That complaint is then followed up on, and as if the circumstances are found to be a violation of the person's rights or of departmental policy, then action will be taken. But the person would then would first have to start that by going to a department and filing that complaint with a superior officer.
Okay, it looks like we have addressed all of the questions, and we have one statement. This person says, "This bill makes me proud to be from Illinois. I look forward to these changes. Thank you to Senator Sims."
Thank you so much, and I truly appreciate that statement. That does my heart so much good. That you think that way about this effort and about this bill and about me in particular. But as much as I thank you on behalf of me, I've got to thank you on behalf of the members of the Illinois Legislative Black Caucus who stood up and saw the need for these changes, who saw the need to address systemic racism. And let me also say this about systemic racism. Often when you say the word racism, there is this negative response. Let's be able to separate systemic racism from someone calling someone else a racist, because they're two very different things. Systemic racism are advantages built into systems for some and disadvantages built into systems for others. So that's very different from someone being called a racist. But so the Illinois Legislative Black Caucus stood up in this moment and said, we want to address the systemic racism which exists in systems, be they education, economics, healthcare, criminal justice, and then to address those challenges. But even beyond that, because at the time there were only 10 members of the Illinois Legislative Black Caucus in the Illinois Senate, and 22 members of the Illinois Black Caucus, the Illinois Legislative Black Caucus in the House. But we need, in order to pass any bill, you need 30 members of the Senate and 60 members of the House, and the governor has to sign it for it to become law. So in addition to those 10 members, there were 22 other members of the Illinois Senate who said, you know what, we need to reimagine public safety in Illinois. We need to focus on making our communities safer. We need to make sure that we improve the profession of policing by holding law enforcement officers accountable. We need to make sure that we are modernizing our thinking and making our justice system more fair and equitable. And we need those things to happen today. So that I'm so proud of the 22 other members who stood with us in the Illinois Senate to say, this is the time to make these changes. Are they going to be the cure to all of our ills? No, but it starts us on the path, and we cannot start on, the journey of 1,000 miles starts with one step. We have got to get started. And I thank my colleagues for standing with me, standing with us. And I thank all of you for coming and listening to this discussion and participating. And those were great questions. I thank you because it also gave me the opportunity to see the perspective and the thinking of community members. And I want this dialogue to continue. So thank you for to the commenter for your statement, and I appreciate you, and I look forward to you working with me, and I look forward to all of you working with me on this reform journey, because I need you. We need you as policymakers. We need your real world lived experience so we can help lift up your voice to make great policy. That's the only way this is going to work, if we work together.
Before our criminal justice chair, Nancy Maxwell, come with the closing remarks, I just want to remind everyone, you can look in the chat for information where you can find the content of the Safety Act, as well as the senator's email address. So Nancy Maxwell.
Good evening, everyone. The NAACP wants to thank Senator L.G. Sims Jr. for taking the time out of his busy schedule to provide the community with truth and knowledge about the HB 3653 Illinois Criminal Justice Reform Bill. The senator reviewed the do's and don'ts of the bill. He provided the timelines for the bill and answered our questions. He also has given us knowledge this evening. Our hope is that you will pass this knowledge on. When you can reach one, you can teach one. Let's remember that knowledge is power. Please share the power. A large amount of information was shared tonight, but please keep in mind the website hb3653.org as a tool for reference. The NAACP wants to thank you for attending this event and wish you all